Thank you for joining us today for our first day of Denton's Ontario Employment and Labor Spring Webinar Series for 2022. I'm Gerga Hegedish, a partner in our Edmonton office, and my practice focuses on tax law. Today, I'm joined by my colleagues, Janice Pereira, who's an associate in our Toronto office, and whose practice focuses on employment and labor law. I also have Jonathan Moore, who's a senior associate in our Toronto office, whose practice focuses on immigration and employment and labor law. I will start off with the tax implications of remote work. Then Janice will provide details on employment law considerations and implications that arise from remote work. And finally, Jonathan will cover immigration issues that can arise from working remotely. And I'll begin my presentation now regarding tax implications on remote work. Next slide, please. So just by way of background, in 2016, prior to the pandemic, about 1 in 20 employees reported working most of their hours from home. Then, during the pandemic, from October to December 2021, 21% of Canadians reported working from home all the time, while an additional 18% work from home some of the time. So a significant rise in the number of people working from home for obvious reasons. It's interesting to note that 75% of workers who worked from home all the time reported being very satisfied or satisfied with the balance between their job and home life. So definitely a trend seeing people working at home more often, but also people seem to be enjoying the working at home. So it's likely a trend that's going to stay for the long term, at least to some degree. Next slide, please. So in this presentation, I'll talk a bit about what the potential tax impacts are for the employer, as well as the potential tax impacts for the employee. And I'll also talk about some of the expenses that can be claimed due to the fact that employees are working at home, such as home office expenses. Next slide, please. So what are the potential impacts on the employer? Well, one of the biggest impacts that can result from having employees work remotely is the fact that you can inadvertently establish a permanent establishment in another province or territory, or even another country if you have workers who are working abroad. This can impact the tax and filing obligations of the employer and the employee, and it can also have an impact on the payroll obligations of the employer and the employee. Next slide, please. So what is a permanent establishment? A permanent establishment is essentially a fixed place of business through which a business carries on. And it can include a place of management, a branch, an office, and it can include many other things as well, but those are the main things, examples I want to cover. Generally speaking, an employee's home office will not establish a PE as the employer does not exert control over the home office. So if you have people working remotely just in a home office, generally won't mean that they establish a PE in a different location. However, there are other ways you can establish a permanent establishment. For example, if a person habitually exercises the authority to conclude contracts in another country, such as, say you have you're an employer based out of Canada, but you have an employee working in the States who has the ability to enter into contracts on your behalf, then that can establish a permanent establishment in the US under Article 5.5 of the Canada-US tax treaty. There are other tax treaty rules which could cause you to inadvertently establish a permanent establishment in another country. For example, if you're a Canadian employer and you have an employee working in the US, if that employee is present in the US for more than 183 days in any 12-month period, and that person generates more than 50% of the gross active business income from services in that state, then you can establish a PE in the States as well. So that's what would you call a key employee of someone who generates significant profits and they're working remotely. You can also establish a PE in another location. So these are just things to be aware of, but the rules change depending on where the individuals and the employers are located. So you'll have to look at each scenario on a case-by-case basis to determine what the tax implications are. So what happens if a PE is established? Excuse me. Well, if a PE is established, then the employer may be taxed in that province, territory, or country and they may have tax filing and remitting obligations in that location. So it's really important to be aware of the potential for establishing a P in another location through remote work. Next slide, please. One of the other possible results of having individuals work remotely is that it can change the payroll obligations for that employee. And this is because each province imposes its own individual tax rates, and the amount of payroll deduction to be withheld is calculated based on tax rates of the province where the employee reports to work. So if you have a situation where an employee is not required to report to work at any establishment of an employer, say you're an employer based in Ontario, but you have an employee in Alberta, and the employee never reports to work at the Ontario location or any other location, then the employee is deemed to report at the establishment from which remuneration is paid. So since they're paid from Ontario, they're deemed to work out of Ontario, even though they're situated in Alberta. So the withholding rate is the applicable rate in the province where the payroll department is located, as opposed to the province where the employee is located. However, the individual's taxation rate is based on the province in which they reside. So there might be a mismatch there. So it's just something to be considered if you have someone who's originally working in the province where you're situated, but you approve for them to work in another location, it could have an impact on their payroll obligations. Next slide, please. This is also true if you have individuals who are working abroad. So say you have a Canadian employer who hires a foreign resident remote worker. You might have foreign payroll obligations, and you might have to register for a business number in that foreign employee's country of residence. So for example, if you're a Canadian employer and you have employees who are working in the US, you might have to withhold US federal and state income taxes, social security, healthcare tax, and any state unemployment or disability obligations. And to remit the employee's wages and taxes, the Canadian employer will have to apply for an employer identification number. Another thing to consider is if you have a non-resident worker working, say, from Mexico in Canada, then there are also non-resident withholdings that you'll have to consider when you're paying them. Next slide, please. Lastly, I'll talk about home office expenses. So these are expenses that an employee might be able to claim if they're working remotely. They can include the following kinds of expenses. They can include electricity, heat, water, the utilities portion of condo fees, home internet access fees, maintenance and minor repair costs, rent paid for a house or apartment, or office supplies like pens and paper and cell phone minutes. But it's notable that you cannot deduct capital items like office chairs, mortgage interest, and property taxes for home office expenses. Next slide, please. So what are the requirements for home office expenses? Well, there's two ways you can qualify to claim home office expenses. The first way is if the employee principally spends time at that home office to perform his or her work. So principally generally means more than 50% of the time. The other way that you can qualify for home office expenses is if the employee uses the workspace exclusively to earn employment income, and he or she must use it on a regular and continuous basis for meeting clients, customers, or other people in the course of his or her employment duties. And the CRA stated that video conferencing satisfies the definition of a meeting. So if you're using your home office on a regular and continuous basis to conduct video calls with clients, then it can qualify for the home office expense. Next slide, please. So there's two methods that can be used in order to claim home office expenses. And then the simplified method was introduced during COVID for ease of administration because so many people were working from home. I think they wanted to make it easier for people to claim these expenses. So the simplified method allows employees to claim $2 for each day they work from home during the pandemic in 2020, 2021, and 2022 to a maximum of $400 for 2020. And this amount was increased to $500 for 2021 and 2022. So there's a cap for the amount you can claim if you're using the simplified method. But the benefit of using this method is that the employer does not have to complete and sign the form T2200S or the Form T2200. So a bit more ease of administration. But employees don't have to use this method. They can use the detailed method, and this method allows employees to claim the actual amounts they paid for home office expenses. But it's notable that these expenses must be supported by documents, so keep copies of all records like receipts and invoices, so that if you are audited, you have those documents to provide to the CRA to support claiming those expenses. Under the detailed method, you have to complete the Form T777S or Form T777 and get it completed in Form T2200S or Form T2200 from your employer. So there's a bit more of an administrative burden, but it does allow you to claim more than the minimum or the maximum $500 for home office expenses. That concludes my portion of the presentation. So I'm going to hand it over to my colleague Janice for her discussion on the employment law considerations from remote work. Thank you.
Thank you, Gergely, and good afternoon, everyone, or good morning, depending on where you are. Thank you so much for joining us today. So today I'll be speaking about some employment standards implications that go hand in hand with work from anywhere policies. These programs permit employees to perform their work remotely, whether it be from a different province or territory. This session will mainly touch on how the Ontario courts and the Labour Relations Board have addressed the application of Ontario employment standards in circumstances where the employee resides in and performs their work someplace other than Ontario. While these cases tend to be specific to Ontario law, they do provide a flavor of the general considerations and risks that accompany work from anywhere policies. And so I do hope that this session is useful for everyone in attendance today. Next slide, please. So in the era of remote work, where an employee might be residing and performing work from a province that is different from their employer, one of the main questions to ask is which province's laws govern the employment relationship? Now, generally, the answer to that question is the law of the province or territory in which the employee is physically located and where the work is being performed. This can, however, differ based on the applicable employment standards legislation from province to province. So let's take a look at what this might look like based on the Ontario Employment Standards Act. So Xu Zhang versus IBM Canada Limited is a 2019 application that was before the Ontario Labour Relations Board. Now, in this case, the applicant was hired by IBM as a software developer in 2009. In 2010, he sought and was granted permission to work from home in Ontario. This was then crystallized into a work from home agreement between IBM and the applicant, which contained a term stating that IBM could terminate the work from home arrangement at any time and in its sole discretion and require the applicant to transition back into a quote unquote traditional work environment upon receiving 4 weeks of notice of the change. Now, in 2015, the applicant moved from Ontario to Vancouver, BC, and continued to perform the same work remotely while working with a group of his colleagues in Ontario. 2 years later, in 2017, IBM notified the applicant that it was terminating the work from home agreement and required the applicant to relocate back to Ontario and specifically to work out of IBM's headquarters in Ottawa. The applicant refused to relocate to Ottawa, and IBM treated his refusal as a resignation, effective 5 months later in March 2018. The applicant continued to reside in BC and worked out of BC during this 5-month time period. Now, since IBM's position was that the applicant effectively resigned by refusing to relocate to Ottawa, IBM did not provide him with any severance pay. So once the relationship ended, the applicant filed his application before the Ontario Labour Relations Board, seeking severance pay under the Employment Standards Act 2000, or the ESA for short. Before even considering the merits of the application, the Ontario Labour Relations Board first considered whether the Ontario ESA even applied to the employment relationship. Next slide, please. So as we see on this slide, subsection 3.1 of the ESA sets out which employment relationships the Act applies to. So the Act applies if A, the employee's work is to be performed in Ontario, or B, the employee's work is to be performed both in Ontario and outside Ontario. However, the work performed outside of Ontario must be a continuation of the work performed in Ontario. Next slide, please. So the Labor Board rejected the applicant's claim and held that the Ontario ESA did not apply because at the time at which the employment relationship had ended, it could not be said that the applicant's employment was, quote unquote, to be performed in Ontario as required by subsection 3(1)A of the Act. Now, you might recall that pursuant to subsection 3(1)B of the Act that we just saw, the Act also applies if the employee's work is performed both in and outside of Ontario, so long as it's a continuation of work performed in Ontario. In Zhang versus IBM, since the employee had worked out of BC for almost, I believe it was like 3 years at the time at which the employment relationship ended, the Labor Board found that his work was performed exclusively outside of Ontario and therefore could not have been said to be a continuation of his work performed in Ontario. The Labor Board therefore found that the Ontario ESA did not apply and the application was dismissed on that basis. Next slide, please. So as we've seen in Zhang versus IBM, when a remote worker decides to leave the province and perform their work elsewhere, this can have an impact on which province's laws apply to the working relationship. One major risk of a work from anywhere program is that it might render important contractual provisions in an employment agreement inoperable. So for example, let's take a termination provision in a contract that limits an employee's entitlements upon termination to only the minimum standards provided for in the Ontario ESA. Now, let's say that employee, let's call him Joe. Joe moves out of province to Alberta, continues to work remotely, performs his work exclusively from Alberta for the next 10 years. Joe's employment is then terminated and the employer attempts to pay him only his minimum entitlements under the Ontario ESA based on what the terms of his employment contract says. Now, there's a strong likelihood that in such circumstances, since the Alberta Employment Standards legislation would govern the employment relationship, the termination provision in the contract would be deemed inoperable since it references Ontario law. Therefore, Joe would probably be well positioned to argue that he's owed only common law notice, which can be much more significant than the statutory minimum notice amount. And of course, this can come at a significant price tag to the employer. Next slide, please. So you might ask, well, in such circumstances, would it sort of save the day if the employment contract had a governing law clause? So for those of you who aren't familiar, a governing law clause in a contract enables the parties to specify which substantive laws govern the rights and obligations of the parties to that contract. So using my previous example, if Joe's employment contract had a terminate which said something like, this agreement shall be construed and performed in accordance with the laws of the province of Ontario, the employer could argue that Ontario law still applies, even though Joe performs his work exclusively from Alberta. So can a governing law clause always save the day? The answer to that is really, it depends. We can take a look at how the courts and the Ontario Labor Relations Board have treated governing law clauses on the next slide. So in McMichael versus Australian Land Company, this is a 2018 Ontario Superior Court decision. This case involved a plaintiff who was a VP of operations and relocated from Ontario to Los Angeles, California to work at the employer's processing facility. The plaintiff's employment was terminated, I believe, after 12 years of service, and so he sued his employer for a better termination package and notice of common law. The employer argued that the Ontario ESA did not apply because the plaintiff had performed his work exclusively from California for more than a decade. In this case, however, there was a governing law clause in the employment contract which incorporated Ontario law as the choice of law applicable to the contractual relationship. The court found that the Ontario ESA did apply on the basis of the governing law clause and stated that a choice of law clause often bears no relationship to the location in which the contract is to be performed. A governing law clause can therefore be the law intended by the parties. As long as that choice is bona fide, legal, and there is no reason for avoiding the choice on the ground of public policy, then the law will govern the contract. So in McMichael, the governing law clause was sufficient to bring the parties within the scope of the Ontario ESA, even though the employee had exclusively worked in California throughout his tenure with the employer. While this argument worked well before the Ontario Superior Court, as we'll see from the next case, it did not fare so well before the Ontario Labor Relations Board. So Karpowicz versus Valor is a 2016 case before the Ontario Labor Relations Board. So not before the court, but rather before the board here in Ontario. In this case, the board considered whether the Ontario ESA applied to an employee that resided in and worked out of Michigan for the entirety of the employment relationship. The employee did occasionally visit the employer's head office in Burlington, Ontario, and so he tried to argue that he did perform some work in Ontario pursuant to subsection 3(1)(b) of the ESA. The employee also tried to rely on a governing law clause which elected Ontario law in his employment contract. Now, the Labour Board was not convinced by this argument and found that Ontario law did not apply. With respect to the governing law clause argument, the board stated, "It may be that, as a matter of contract, parties can agree to have certain statutes apply to their relationship even when the facts of their relationship make the statute inapplicable. This, however, is a matter for enforcement through the courts. The parties cannot confer authority on the administrative agency charged with enforcing the statute to deal with their dispute when the statute is, on its face, inapplicable to their dispute." So while in the previous case, McMichael, the court was able and willing to apply the governing law clause, the Ontario Labour Relations Board found that it did not have the authority to apply such a clause. And it also held that given the substance of the work, where the work was performed by Mr. Karpowicz outside of Ontario, and given that some incidental though necessary work was occasionally performed in Ontario, the Act has no application. The Act was, or rather the application was therefore dismissed by the Labour Board. Next slide, please. So what these two cases show us is that a governing law clause can't always lock parties into the applicable laws of a certain province, and therefore it doesn't always bring certainty to the employment relationship where the remote work is done from outside of the province involved. Further, the case law suggests that there's no real clear-cut answers to the question of how much an employee must work while physically present in Ontario in order for the relationship to be governed by Ontario's ESA. Rather, the specific circumstances of the work arrangement will likely be very relevant, including, for example, the extent to which the employee's work duties relate to the work performed in Ontario, how often the employee performs employment duties while physically present in Ontario, and whether the employment agreement contains a governing clause that explicitly selects Ontario law to apply. Bearing this in mind, employers really should think carefully before permitting employees to work remotely from outside of Ontario for extended periods of time, and should consider how such out-of-province work might impact their employment entitlements. Some other quick issues to flag that accompany remote work arrangements is that workers' compensation schemes can vary greatly by province. Different provinces also have different triggers for overtime pay. So for example, in BC and Manitoba, if a non-exempt employee exceeds 8 hours of work in a day, they would be qualified for overtime pay. But in Ontario, an employee would only qualify for overtime pay if they exceed 44 hours of work within 1 work week. Now, it may seem that things get complicated quickly if employees work remotely from other jurisdictions within Canada, but these issues are compounded even further if an employee works remotely from another country for an extended period of time. And there are different creative and context-dependent solutions to help employers sort of manage such risks. And if you are an employer and you are considering implementing a work from anywhere policy, we definitely encourage you to seek legal advice. So that is all that I have for today. Thanks so much for listening. I will now pass it over to my colleague, Jonathan Moore, who will be speaking about work from anywhere policies and some implications from an immigration law perspective. So over to you, Jonathan.
Thanks, Janice. Hello, everyone. I'll be covering the immigration part of our discussion today, and I will jump right in. Next slide, yes. So work from anywhere or remote work policies also create risks under Canadian immigration law. To understand these risks, we will look at 2 primary factors. The first is, where will the employee be working from? Will they stay in the same province or territory as the employer? Will they relocate to another province or territory, or maybe to another country entirely? The second factor we will look at is the employee's immigration status in Canada. Next slide, please. Although it sounds obvious, it's worth mentioning that Canadian immigration law only applies to those who are physically in Canada. This means that remote work from another country has no implications under Canadian immigration law, regardless of the employee's immigration status. This does not mean that there aren't any risks, as this may or may not be allowed under the laws of the destination country. So employers need to consider these arrangements on a case-by-case basis, since the law does vary from country to country. For work from anywhere arrangements within Canada, we do need to look at the employee's immigration status. Next slide, please. So in terms of status, we will look at these policies in the context of Canadian citizens, permanent residents, and temporary foreign workers. Next slide, please. So for Canadian citizens, we can start by looking at the Canadian Charter of Rights and Freedoms, which says that every citizen of Canada has the right to move to and take up residence in any province and to pursue the gaining of a livelihood in any province. The Charter therefore grants Canadian citizens mobility rights within Canada. So when applied to Canadian citizen employees, work from anywhere policies don't create any risk, at least as far as Canadian immigration law is concerned. Next slide, please. A permanent resident of Canada can be thought of as a Canadian citizen minus a few rights. For example, permanent residents can't vote. So can a permanent resident employee move to another province or territory and work from there on a permanent basis? Next slide, please. So we'll see that the Charter grants the same mobility rights to permanent residents as it does to Canadian citizens. Permanent residents should therefore have the same freedom to live and work in any province or territory with one qualification. Next slide, please. Whether a permanent resident should relocate to another province depends on how they became a permanent resident in the first place. If they used one of the federal permanent residence programs, such as the Canadian Experience Class or Federal Skilled Worker Program, there shouldn't be any risks to relocation. So for purposes of a work from anywhere or remote policy, they can be treated just like a Canadian citizen. On the other hand, if they used one of the provincial or territorial immigrant nominee programs, there may be some cause for concern. Next slide, please. So for background, a provincial or territorial immigrant nominee program, or PNP, allows a province or territory to nominate eligible foreign nationals and facilitate their path to permanent residence. Each province or territory has its own set of application streams, such as those for international students and skilled workers. Next slide, please. Most nominee programs require the applicant to demonstrate an intention to remain in the province or territory. Some examples include an intention and ability to live and work in Alberta, an intention to live, work, and economically establish in British Columbia, and an intention to live in Ontario after obtaining permanent residence. Next slide, please. So we saw that the Charter grants mobility rights to permanent residents. And to clarify, by using a nominee program, permanent residents aren't waiving their mobility rights under the Charter. The risk of relocation under a work from anywhere policy comes from a different angle. If the permanent resident moves to another province or territory, the nominee program may have reason to suspect that they never intended to stay in the first place. A nominee program can choose to investigate whether they misrepresented their intention during the application process, and if it finds that a misrepresentation did occur, it can begin proceedings to revoke the employee's permanent resident status. Next slide, please. This doesn't mean that a permanent resident who used the nominee program must live in that province for the rest of their lives, but timing of the relocation should be considered. An investigation is most likely when the permanent resident doesn't ever establish themselves in the intended province or territory, or only lives there for a short period. Unfortunately, There isn't exactly a bright line rule for when relocating to another province would carry zero risk of an investigation. It's worth mentioning that this scenario doesn't present any real risk to an employer, aside from potentially losing the permanent resident employee. Next slide, please. Work from anywhere policies pose the greatest risk for employers where a temporary foreign worker is concerned. Whether there is a risk and the degree of risk depends on the terms and conditions of the employee's work permit. We'll look at two types of work permits: open work permits and closed work permits. Next slide, please. An open work permit allows a foreign worker to work for any employer. Most also authorize the foreign worker to work in any occupation and, for our purposes, from any location in Canada. For employees with an open work permit allowed to work and who are allowed to work in any location, there are no risks to the employer. Next slide, please. Closed work permits, on the other hand, only authorize foreign workers to take up employment with a specified employer. In these cases, work location is also usually restricted. And this is where a work from anywhere policy creates the risk for an employer. Closed work permits are issued under two programs. First, the Temporary Foreign Worker Program, where employers must first apply for a labor market impact assessment, or LMIA, in order to hire a foreign worker. And the second is the International Mobility Program, where employers can hire foreign workers without an LMIA through one of the many exempt work permit categories, such as the well-known intracompany transfer. Next slide, please. Obtaining a work permit under the Temporary Foreign Worker Program is a two-stage process. Employers first apply for the LMIA from Employment and Social Development Canada, or ESDC. And as part of this process, employers disclose and commit to various conditions of employment. The important condition for our purposes is that employers commit to specific addresses where the foreign worker will work. The LMIA that results from this process is then tied to these specific addresses. In the second stage of this process, the foreign worker obtains a work permit based on the terms of the LMIA, which means that the foreign worker is only authorized to work at the addresses disclosed during the application process. Next slide, thank you. Obtaining a work permit under the International Mobility Program is a one-stage process, but one that requires employers to complete an online regulatory filing known as the Offer of Employment. Like the LMIA application form, the Offer of Employment filing collects details regarding the foreign worker's conditions of employment, and again, the specific work addresses must be disclosed at the outset. The work permit that results from this process is tied to the Offer of Employment, and the foreign worker will only be authorized to work from the locations specified in the Offer of Employment. Next slide, please. Under both the Temporary Foreign Worker Program and the International Mobility Program, employers are required to comply with a number of requirements, and the important one for our purposes is adhering to the terms of the LMIA or Offer of Employment, including work location. By participating in either of these programs, employers can become subject to an inspection by ESDC. The purpose of the inspection is to confirm that the terms of a foreign worker's employment is consistent with the information provided during the LMIA application process or in the Offer of Employment filing. Inspections can occur if ESDC has a reason to believe that an employer was non-compliant with the terms of the LMIA or Offer of Employment, or more commonly, the employer was simply selected randomly. Compliance with the terms of an LMIA issued under the Temporary Foreign Worker Program is assessed on a strict basis. Deviation from the terms of employment in the LMIA will usually result in a finding of non-compliance unless there is some strong justification for the deviation. Compliance with the terms of an offer of employment under the International Mobility Program, on the other hand, is assessed on a somewhat more forgiving basis. Next slide, please. In the context of a compliance inspection under the International Mobility Program, some guidance does exist as it relates to work location. A change in work location from what was provided in the offer of employment will be considered non-compliance if it would affect the decision on a work permit application or result in the foreign national working without authorization. The risk of relying on this guidance is that it involves speculation. If the new unauthorized work location had been disclosed during the application process, we would have to guess whether the work permit application would still have been approved. We can consider this in the context of two scenarios. In the first, the foreign worker is only authorized to work from employer office A, but then begins to work from employer office B. Here, unless there is some reason to believe that disclosure of the Office B work location during the application process will have caused the application to be denied, we can safely guess that the risks are lower here. In the second scenario, the foreign worker is only authorized to work from employer office A, but then begins to work from home. This is almost certainly a higher risk change, since a work permit application may well have had a different outcome if it were disclosed at the outset that the employee would be working from home. Next slide, please. Findings of non-compliance following an inspection do carry consequences for employers. These could include simple warnings, monetary penalties that have a fairly large range, a permanent ban from the Temporary Foreign Worker Program and the International Mobility Program for the most serious violations, and such a ban would make it difficult for employers to hire temporary foreign worker talent in the future. It can result in a publication of the employer's business name on a government website, and non-compliance can also result in suspension or revocation of previously issued LMIAs for unrelated employees. In conclusion, a finding of non-compliance that results from allowing a foreign worker to work from an unauthorized location is unlikely to carry the most severe penalties for an employer. However, the employer would still risk a warning or monetary penalty. And since penalties for non-compliance are cumulative, severe consequences are still possible if an employer is found non-compliant for multiple violations. Work from anywhere policies carry no risks to the employer under immigration law, at least when applied to Canadian citizen employees or permanent resident employees. Although there still may be consequences for the permanent resident employee who relocates to another province after using a nominee program. Finally, when applied to foreign workers, work from anywhere or remote work policies can create significant risks. Employers should therefore have a mechanism in place for reviewing the terms and conditions of each employee's work permit before authorizing relocations. Thank you.
Thanks, Jonathan, and thanks, Janice, for your presentations. We just have a few questions in the Q&A, so we'll hop right into those. If you have any additional questions, please feel free to write them in there now, or you can contact us afterwards by phone or email, which should be in the presentation. So one of the questions was, will the deck be shared following the webinar? And the answer is yes, we will be sharing a PDF version of the deck, and a recording of the presentation will also be posted. So if you really want to watch it again, please feel free to click on the link. A couple of questions about taxation. So firstly, do the PE taxation rules apply to companies who use independent contractors in a particular US state? Your example referred to employees. So these questions are really fact specific. If you're dealing with a Canadian company and a US an individual who's going to a US state, then you'd be looking at the Canada-US tax treaty, and there is an exception under Article 5, paragraph 7, which states that basically, if a company is carrying on business in another state through a broker, general commission agent, or other agent of independent status, then you won't be establishing a permanent establishment in that location, so long as that person is acting in the ordinary course of their business. But it's important that that independent contractor or agent must be both legally and economically independent. So it's really still a fact-specific question that you have to examine the particulars of the case to determine whether a PE would be established. The second question we have is, if a Canadian employee has dual citizenship or has a TN visa and they go to the US to work from a home office, this alone will not create a PE for the Canadian employee, provided they limit their visit to less than 183 days. So the citizenship and the visa status of the individual won't impact whether you're establishing a PE. What will matter more are factors such as whether the individual can enter into contracts on behalf of the company. If so, then you might be establishing a permanent establishment in that country. So you have to look at a number of factors, but the citizenship and the visa status aren't one of them. They can impact the individual's taxation status as to whether they're taxable in Canada or the US. So, but it's not relevant for determining whether a PE would be established. Third question, is there a minimum amount of time working in another country that an employee can work where it won't impact taxes or other legal obligations? For example, if an employee wants to work temporarily in another country for about 2 to 3 months. So unfortunately, there's no bright line rule. You have to look at the individual circumstances. You have to look at what country they're actually going to, because the laws will depend on where they're going and what tax treaties Canada has entered into it with that country, if there's any, and the domestic tax laws of that country. So unfortunately, there's no hard and fast rule, and you really have to look at each individual case. For example, Canada will generally tax people if they spent more than 183 days in Canada. So they'll be deemed to be residents of Canada. So that's just one example, but it really depends on which country they're going to. And so you have to look at the domestic laws and the tax treaties. And lastly, what risks would we have if we have a permanent employee who will be moving to the UK with his wife, who's being transferred to the UK for 2 years? We want to continue having this employee work for us from the UK. Well, you'd have to look at the Canada-US tax treaty, and under Article 5, paragraph 4, it states that if a person has the ability to conclude contracts in the UK, unless his activities are limited to the purchase of goods or merchandise for the enterprise, then you can establish a permanent establishment. So that's just one example of a factor you'd have to look at in determining whether you would be establishing a permanent establishment there. And also, that individual would have to consider whether they're becoming a resident of the UK for tax purposes and subject to tax there, in which case that would impact whether you'd have to withhold non-resident source deductions, withholdings. So lots of things to consider, but it really depends on the particular facts of the case. And it's impossible to give broad answers to these questions because there's so many factors to consider, but just wanted to give you some of the ideas that you might want to consider when you're dealing with these issues. So thanks again to Janice and Jonathan for presenting, and thanks to all of our attendees for coming today. Hopefully you found it informative. Be sure to subscribe to our Employment and Labor Law blog and Canadian Employment and Labor Law podcast to get the latest updates. Details can be found on our website and will be shared in the post-event email you'll receive next week. Day 2 of this series will take place tomorrow at 12 p.m. Eastern, and will cover Ontario's disconnect from work law, an update on non-competes, and a WSIB update. So be sure to join that. As I mentioned earlier, we have developed a ready-to-use Ontario disconnecting from work policy template that can be easily integrated into our employee policy handbook, and this is available to any employer who requires such a policy for a flat fee of $1,000. You can find a link in the chat below, which Peggy has just posted. Thank you. And so be sure to check it out. And last but not least, we're hosting the 33rd session of our legal update for Canadian employers webinar series on Friday, May 27th at 12 p.m. noon. So look out for the invitation. Be sure to add it to your calendar. Thanks again very much for joining us, and we're going to let you go early so you have a bit more time in your day. Thanks again. Bye.